am attorney Marie-Chris Bathan-Lasco. This is my virtual classroom. Welcome to my YouTube channel. In this channel, I shall aim to simplify the law. I will discuss concepts and principles of law in under 10 minutes. Hi again, everyone. Welcome back to my channel. For this video, I want us to talk about meetings of your stockholders or members. When should it be held? Where should it be held? And basically, why is there a need to hold meetings of stockholders, and what would they be talking about? What would they be discussing in the stockholders or members meetings? So let's begin. Let's start off with the kinds of meetings that may be held by your stockholders or members. There are two kinds of meetings under your corporation code. You have the regular meeting and you have your special meeting. What is a regular meeting? A regular meeting is a meeting that is held annually. When will a regular meeting be held? It depends. It depends on the date that is written in the bylaws of the corporation. If there is no date fixed in the bylaws, then your corporation code tells you that the meeting is to be held after April 31 of every year. What is a special meeting? A special meeting is a meeting that is called either by the stockholders or it could be called by the board of directors for the stockholders or members vote on a certain corporate act. By the term itself, it's a special meeting, so it can be called so long as they deem it necessary to be called. Or if there is such a date provided in the bylaws, then they will have to follow the bylaws. How about for regular meetings? That which we said is to be held annually. Usually, and as a general rule, the annual meetings are actually called for the purpose of election of the board of directors or board of trustees in a non-stock corporation. Does this mean then that you cannot address or meet about other matters apart from the election? No. In fact, your annual meeting may also tackle on matters as the stockholders or members may deem necessary. In fact, under Section 49 of your revised corporation code, it would tell you that in the stockholders or members meeting, there must be a presentation of the minutes of the last meeting. And of course, other matters may also be taken up in the annual meeting. You can look into Section 49 of your revised corporation code. Now, why is it necessary to hold meetings for stockholders or members? In fact, in another video, I will talk about also the necessity of holding meetings for your board of directors or board of trustees. But for this video, let's focus on the stockholders and your members. So again, why is it necessary to hold such meetings? We have to remember that corporate powers are vested in the board of directors or trustees or in the stockholders or members as a body. They cannot act individually. And so, for them to decide on certain corporate matters, on certain corporate acts, they have to act as a body. And they can do so by holding such meetings. Again, either a regular meeting or a special meeting. You also have to remember that before a meeting can be held, you have, of course, to notify the stockholders or the members of such meeting. When should such notice be sent to the stockholders or members? And how is the notice being sent to the stockholders or members? These are also matters that are covered by your revised corporation code. So, when should a notice be given to your stockholders or members? If it is a regular meeting, and when should the notice be sent to the stockholders or members if it is a special meeting? If it is a regular meeting, the notice must be sent to all the stockholders or members of record 21 days prior to the meeting, unless there is another period provided for in the bylaws. In other words, if there is a period provided in the bylaws, then you follow that period in the bylaws. Because if you can still remember, and if you have seen the other video on bylaws, the bylaws would serve as the law of the corporation, that rules or those rules and regulations that must be followed by the stockholders or members, the directors or the trustees. So if there is a period in the bylaws, then you follow that period. Of course, if there is no period mentioned in the bylaws, then you follow that which is provided in your revised corporation code. And your revised corporation code tells you that the notice to a regular meeting must be sent to the stockholders or members of record 21 days prior to the meeting. How would the notice be sent to the stockholders or the members? Your Section 49 tells you that the written notice of a regular meeting that must be sent to the stockholders or members of record, that must be sent either through electronic mail or any other means by which the law allows. And what does the law allow, or in what way is the notice sent that is allowed by law? It could be through personal service or it could be via mail. So your corporation has several options by which to give the written notice. Again, your Section 49 says it can be sent through electronic mail or any other means allowed by law or the commission under its guidelines. How about for special meetings? Just the same, a written notice must be sent to stockholders or members of record. When should it be sent? Your revised corporation code, still under Section 49, tells you that it must be sent 1 week prior to the special meeting, unless another period is provided for in the bylaws. So again, you look at the bylaws first. If there is a period written in the bylaws for when you should send notice to the stockholders or members of record for a special meeting, then you follow that period. However, if there is none, then you follow what is provided for by law, and that is 1 week prior to the meeting. Just the same, you may send the written notice through electronic mail or any other manner allowed by the law, which is your personal service of the written notice, or it could be via registered mail or via mail. Now, if you are a stockholder or a member of a corporation, can you waive the written notice? The answer is yes. You can personally waive having written notice of a meeting. In fact, even if you did not receive any notice and you attend the meeting, that is considered as a waiver of the written notice, unless of course your attendance there was for the purpose of objecting to the meeting because you were not given a notice. It can be waived expressly or impliedly then by your stockholder or member. What is not allowed is a general waiver. When we say general waiver, meaning that there is a waiver in the bylaws or a waiver in the articles of incorporation. That type of waiver of the notice is not allowed because it should be the stockholder or member himself who must expressly or impliedly waive the requirement of notice in a meeting. Now we have talked about when the meeting, whether regular or special meeting, when should that be held? And we have also talked about the notice of such meetings, how that is made, and when it should be sent. Now, how about the place where the meeting must be held? Where should regular meetings or special meetings be held? As well as what time should the meetings be held? Section 50 of your revised corporation code tells you the place and time of the regular or special meetings. Section 50 tells you that stockholders or members meetings must be held in the principal place of business of the corporation if practicable. If, however, the principal place of business is too small to accommodate all the stockholders or members, then your law allows that such meetings be held in any other place so long as it is within the city or municipality where the principal place of business is located. Now, who are the proper persons who can call a stockholders or members meeting? Usually you find that in the bylaws. So you look at the bylaws and see who are these persons who may call the stockholders or members meeting. Now, what if it is not stated in the bylaws? In the absence of such provision in the bylaws, then any director or trustee can call a meeting for the stockholders or the members. Or it could also be any officer entrusted by the management of the corporation to call such meeting. Can a stockholder or a member call a meeting? The answer is yes. You can actually find that under Section 49 of the Revised Corporation Code. A stockholder or a member, by petitioning the Commission or the Securities and Exchange Commission, may ask the SEC to call on a meeting. In other words, it's initiated by the stockholder or the member. However, this will only apply if there are no persons authorized in the bylaws, or if there is such person authorized by the bylaws but he refuses to call a stockholders or a members meeting. And so, any stockholder or member, by petitioning the SEC or your Securities and Exchange Commission, may ask the SEC to call the meeting for stockholders or members. Now let's talk about the quorum in the members or stockholders meetings. Again, what is a quorum? A quorum is the required number that must be present to be able to carry on a legitimate business or to be able to carry on a corporate action. Otherwise, if you do not reach that required number, then you cannot do anything except to adjourn the meeting. So what is the quorum that is required for members or stockholders meetings? You'll find the answer under Section 51 of your Revised Corporation Code. Your Section 51 will tell you that the quorum required in a stockholders or members meeting would be majority of the outstanding capital stock for a stock corporation and majority of the members if we're talking about a non-stock corporation. What is majority? Majority is 1/2 plus 1. Now again, you have to remember that if we're talking about a stock corporation, it is not the number of stockholders that we look into to determine the majority or to determine the quorum. Rather, it is the outstanding capital stock. So, for example, if there are 10 stockholders and you are looking into the majority of the outstanding capital stock, then you look at their percentage of ownership. So if there is one stockholder there who actually owns 60% of the outstanding capital stock, then there is actually already a quorum with him only present. Because again, the quorum for stock corporations, you would look into the outstanding capital stock. Of course, that is not the same for non-stock corporations because then you will look into the number of members. So if there are 10 members of a non-stock corporation, then the quorum would be 1/2 plus 1. And what is 1/2 plus 1 of 10? That is 6. And so for them to be able to validly hold the meeting, there must be at least six members in the meeting. That is the difference in determining the quorum for stock corporations and for non-stock corporations. Now, all those matters that I have actually discussed are all the requisites for a valid meeting for members or stockholders to take place. So just a quick review, what then are the requisites based on what was discussed earlier on? For a meeting of stockholders or members to be valid, then first, the meeting must be called by a proper person, and we have already discussed who are the proper persons who can call such meeting. Second, there must be a previous written notice, unless, of course, the stockholder or the member would expressly or impliedly waive such right. Third, it must be held at the proper place, and we have also discussed where that is earlier on. Fourth, it must be held at the specified date and time that was called for. Either it's in the bylaws or you follow the provisions of the revised corporation code as also discussed earlier on. And lastly, the fifth, that there must be a quorum. When we say that these are the requisites to have a valid meeting, that means that all of these five, the five that we just enumerated, must be present. So what then is the effect if one or two or more of the requisites are not present? The general rule is the proceedings of that meeting will be considered as invalid, because as we said, all these requisites must be present to consider the meeting as validly held. However, your revised corporation code also admits of exceptions, that even if there are certain requisites, those that we have enumerated earlier on, if one of two are not present, the proceedings may still be considered as valid. However, these two conditions must be present. What are these? First, that the business transacted during that meeting is within the powers of the corporation, meaning that it is not an ultra vires act of the corporation. And second, all the stockholders or members are present or duly represented in that meeting, such that even if the notice may not have been sent or that it may not have been held in the proper place or any other of the one of the five requisites that we mentioned earlier on was not followed, the transactions or the meeting that was held may still be considered as valid so long as those two conditions are present. Again, what are these two? That first, the proceedings or the transaction, the business transaction that was carried during that meeting is not an ultra vires act of the corporation. It was within the powers of the corporation. And second, that all the stockholders or members are present in that meeting or duly represented in that meeting. So that's about it for meetings of your stockholders or members. These are the most important provisions with respect to meetings of stockholders or members in a corporation. I hope that you have learned something in this video, and I will see you in the next video where I will discuss the meetings of your board of directors or your board of trustees. I will see you in the next. So if you find this video helpful, please click like, subscribe, and that notification bell so that you will be notified of new video uploads. Thank you for watching. See you next time in MBL Classroom.